Good evening, Crime Talk aficionados. Thank you for joining us on our Tuesday night live. I understand and I apologize. We were a few minutes late, but I have a good explanation. First, today is the Marine Corps birthday. That's right, 10 November 1776. Some 245 years later, the Marine Corps is still around. And every year on 10 November, if you've ever served in the Marine Corps, you have two birthdays, the date you were born and the Marine Corps birthday. It's just the way it is. And then, literally, maybe 10 minutes before we were ready to go, we were actually ahead of schedule, which seems like it never really happens because, well, I'm usually done trying to finish up lawyer stuff throughout the day to make this 6 o'clock time. And then a blast from the past. My friend from the Marine Corps, we went through the basic school together. We went through Naval Justice School together. We were stationed at the same duty station together. He was a prosecutor. I was a defense attorney. When we both went to the drill field, we went together. Haven't spoken to him in several years. Called, wished each other a happy Marine Corps birthday. It's always good to catch up. And so big shout out to obviously the Marine Corps. Big shout out there to Colonel Cadwalder. He stayed in obviously a little longer than I did. He retired. Now he's some fancy academic teaching at some Northeastern school. But the next time I'm on the East Coast and in the Boston area, Rhode Island area, we will stop and say hello. And he offered to take us sailing, which I told him I will take him up on definitely. So that's the reason why we're late. All right. Thank you very much. For those of you who do not know me, my name is Scott Reisch. This is Crime Talk. We talk about crime, true crime. We talk about cases in the news. We talk about the legal, the evidentiary things that people hopefully get explained to them by me that you're not going to get on the evening news where someone's trying to explain the legal process, the evidentiary rules, and most importantly, the tactical decisions that are made by both the prosecution and the defense as it relates to these cases that we're discussing. I've been doing this, not YouTube, but I've been a practicing attorney doing primarily criminal defense for 25 years. And so not going to say I have all the answers, but I can usually predict the way things are going to go simply based upon having done so many criminal cases over the years. And not to toot my own horn, but just for credibility purposes here, yes, I like to say I can walk the walk and talk the talk. I have walked 7 people, walked them out of the courtroom on 7 first-degree murder cases in my career. Some people never get that one time in their career as a criminal defense attorney. So, like I said, not necessarily to brag, but to say credibility-wise, I know what I'm talking about. I've handled those type of cases. Now, obviously, some of the cases that have been in the news, we've got the Lori Vallow matter. Then we got the Chris Watts guy who just simply will not go away. And we had the story today where Chris Watts is being disciplined in jail. And, we'll let people choose, decide for themselves. But apparently, Chris Watts admitted that he gave some of his personal items, personal items, very personal items, to another inmate by the name of inmate Talman. And apparently, inmate Watts admitted to giving inmate Talman his own personal books, hygiene products from Canteen, which included a toothbrush, petroleum jelly, shampoo, soap, coffee, and his own personal Fruit of the Loom boxers. Now, who knows? There could be a million reasons why this other guy has Chris Watts' boxers, his underwear, in his cell, along with his petroleum jelly. Perhaps the petroleum jelly is for his dry lips. I do not know. Perhaps Mr. Talman has nobody to put money on his books, and therefore Chris Watts was simply being a good guy and helping him out. We, ladies and gentlemen, are not going where your minds are thinking. That's right. We're not going there. All right. We would like to think that there was just a, good Samaritan reason for that. Now, obviously, there were some people that came forward, I think, that stated a guy who stated that he had met Chris Watts prior to all his legal issues. But you never know. I mean, he's a guy. I mean, he's in custody. I've seen it happen before. I once had a case, it was in federal court, and there were co-defendants, and my guy was completely separate. He was a tough dude. I mean, he was a tough dude. And the other two guys were there, and, I just thought they were co-defendants, and they, kind of buddies. I didn't realize how close they had become while in custody. Apparently, they would do just about anything to stay together. So I don't know. Maybe, the guy needed a pair of skivvy drawers. Maybe that's what it was. And maybe Chris Watts was simply, maybe he was simply just helping a good guy out. Then on the other hand, maybe, like I said, I'm not going there. You all can let your minds wander and go there, but I'm not going out there. Just like I said, a couple guys looking out for each other. And also apparently Chris Watts was using his phone numbers to make calls for this other inmate, and then apparently having his family members talk to this Talman guy as well. Apparently they both got disciplined, loss of commissary, as well as loss of being able to go and use the telephone. You have to remember, telephone is a big deal when you're in prison. Let's face it, people just don't write nice handwritten letters like they used to. Every now and then I still get one from jail, but most places these days have you can email inmates. So it's a different world. So we'll leave that there for you all to ponder and perhaps speculate as to what was taking place. Like I said, maybe something completely innocent. Maybe they're just buddies helping each other out, looking out for each other. You never know. And who are we to? I mean, I'm not judging, but we certainly know that near the end of Chris Watts' freedom, he had a very strong sexual desire, obviously, to be with his girlfriend, Nicole Kessinger, if that's in fact her real name anymore. We don't really know. And since the court has sealed all the records pertaining to her, name change, even when I show up and the judge kind of knows why I'm there, just here to observe, Your Honor, just watching. I'm sorry, I don't see the Kessinger matter on the docket. And she just smiles at me and looks and says, okay. I said, oh, let me guess, that's been suppressed. Because there's what reason to hide information from the public in a normally public proceeding? That's one thing, ladies and gentlemen, that most people aren't aware of. As we become more and more digital, it's so much easier for everyone to simply hit the button and nobody has access to it. That is a very scary thing, all right? It used to be literally you could walk into any courthouse, anywhere, write out the name, who you were looking for a file, and you could get it. You get a copy of all the court records, you get a copy of all the pleadings that had taken place, and that was it. Nobody blinked an eye. You could copy it. As long as you didn't take it out and do something inappropriate with it, you had complete access to that court file. Like I said, you could photocopy it. You could sit there and review it and take notes. Now everything's online. You can't walk into a courthouse anymore and say, I'd like to take a look at this record. Now, of course, they make you buy it to take a look at it. And then on top of that, you also have to do, you have to make sure that they have to redact everything. So if you request a file, they're going to redact it and take out all the information, all the identifying information, which is like it's public information. And the rules are here, but it's getting a little more difficult, hopefully, where the judge can say, I think this is a case that should be kept quiet. And the people who run into this the most is actually the news media. The news has to go to court and say, why should this case be suppressed? What is so compelling that the public's right to know in a free and open society is somehow trumped by this particular person's expectation of privacy? Yeah, I'm not saying there shouldn't be exceptions to the rule, that it should be public record, but you should have a pretty significant reason for denying access to public records. It's a little scary how it is these days, and nobody ever seems to think much about it until it actually affects them, until they need to do something to actually want to go check something out, to research something. It's public record, ladies and gentlemen. That's what makes a free society free. All right? You go to some countries, you can't get access to anything unless you pay somebody off. Wrong. We don't need that. We need free and open to the public. Sure, pay for the cost of making copies, but that's about it. All right, there's a little, got a little sidetracked there. Now, also, we have, obviously, Lori Vallow and Chad Daybell. They're still out there taking their time, getting to trial, waiting for motions to be filed. I'm sure Mark Means, the attorney for Lori Vallow, will drag his feet, request more time. Discovery hasn't been turned over, so it's just, it'll take forever. Now, let me look at one of the comments here. It says, I live in Charlton, West Virginia. I go to the circuit clerk's office and request a file and paperclip the pages I want copied of and pay $1 per page, and I get it. We're a little behind technology. The good old days there, Emma. Those were the good old days. Yes, even better yet when you can have the clerks of the office pay, you just clip it and they have to make the copies. As I remember being a law clerk, having to photocopy, cases before. You didn't just go to Westlaw and print them out. Everything wasn't actually, you had to actually go to the library and find them and take them and put them out and photocopy them, and stood in front of that copier forever. It was always, the joke was, one day when I wanted to have children, was I going to be sterile because the copier would have somehow made me do that, done that to me. It was a whole different world. So, all right. So jumping back then. So then we have Nicole Kessinger out there. Oh, I'm sorry. Then we have Lori Vallow and Chad Daybell dragging on. Now, there was the audio recording released by one of the ex-husband's sister the other day where Lori Vallow's on there saying that she wanted to, kill the husband. Now the authorities said, yes, we'll look into it. It's not going to change much of anything, in my humble opinion. We'll just have to wait and see. All right, a couple of questions here. It says, what does the YouTube plaque mean? Let's see, this is from Michelle Gerber Anderson. Well, this little bad boy right here, that's the little plaque that you get from YouTube when you reach 100,000 subscribers. Now, you may think, well, how difficult is that? Well, we looked it up because it seems like it took longer, and they just don't give them out. I assure you of that. In fact, once we went past 100,000, we didn't actually get it shipped to us till we were over, I think, 150,000, because you say, hey, can I get my plaque? And you get no response from the YouTube people. I'm not really sure there is really anyone that works at YouTube. There may be like one or two people at most. But I think it's all completely, artificial intelligence. So if your question doesn't fit within their answer, I think it just goes off. And 8 months later, the two people that work at YouTube will actually do that. And I think we looked it up. There are literally 30 billion? 30 billion, yeah. 30 billion YouTube channels out there. And what was it, 1%? I think 1% of all the channels ever get 100,000 subscribers. So that's a pretty elite club. So I'm kind of proud of that little bad boy. And I think when we started this channel, at first I was like, how tough could this possibly be to start a YouTube channel, right? I mean, you just turn it on and go. Let me tell you, it has been it's been fun, but there have been days that have been completely frustrating. Trying to learn how to do things that I should not have wasted my time on doing. I remember once I was in the office on a Saturday, I was trying to make a thumbnail, and I was messing around with this thing for literally 2 hours. And my assistant came in to do something, and I said, can you fix this for me? Like, I've been doing this what am I doing wrong? And in like 30 seconds, she was like, oh, you got to resize it, and then bam, it was just like that. And at that moment, I realized I cannot do this myself. And there's no way that we could put out a daily show at least 5 to 6 days a week if I were doing this all myself with, just me, myself, and I. Couldn't been able to do it. We've hired a couple people along the way. Kyle was with us for a while. Had some people in other states try to help us, but that was just too complicated. Now we got Frank that's been with us, has been great. And so, it's been fun, but it's much more difficult. I think people think that, you started. It's like everybody thinks, oh, you're self-employed. You must be absolutely wealthy, rolling in it. No, money comes in, money comes out. And I think a lot of people think, oh, we start a YouTube channel. Doesn't like everybody have a video that just goes viral and everybody has like 1 million subscribers? No. And if you don't believe me, put up a video. Just put it up there. Like, why would anybody come look at it? It's much more difficult than you think. So a lot of work's went into that. That's why I think I'm kind of proud of that little plaque there. But you don't get another one, I think, until you literally get to 1 million subscribers. So I got a little ways to go, but maybe all of you, if you haven't done so already, you could like the page, share it with your friends and family, tell them to like the page, subscribe to the page is what I really meant. And next thing you know, we'll have 1 million plaque up there, which would be really cool. Let's see here. Question. This is a super chat. Now, we always appreciate super chats, but never required. But I'll be honest with you, it is so much easier to read a super chat than some of the scrolling questions that go by rather quick. Terry Dalton, did you notice that Lori never mentioned that Joe Ryan was dead in that recording? I wonder why or why not. Well, I think she was, probably trying to make it as dramatic as possible. This was, some sort of explanation as to why she was going to the church, when I was listening to it. And no, she never mentioned that he was in fact actually dead and supposedly died of natural causes. So I'm not really sure what anybody is going to do. The police can say, yeah, we'll look into it. We'll always investigate leads to satisfy family members. But the reality of it is nothing's going to come from it. So yes, thank you everyone who donates to this channel. All the benefits and generosities. I mean, thank you all. I mean, we do really seriously take this, appreciate this, because we know that there are so many options out there. In fact, there's 30 billion options out on YouTube. So the fact that you've been able to find us and you find that what we've had to say is something of value, we appreciate that, and it doesn't go unnoticed. And we are constantly thinking and trying to find interesting things to talk about so that we can bring it to you and hopefully find that it's completely interesting. Wow, live Denise, thank you. $49 super chat. Wow, appreciate it. Thank you, thank you, thank you. Let's see here. The questions are always good. Now we all have to fear idiots castrating people and demanding. Yeah, well, yeah. Assuming that's in regards to the story the other day we had about the two gentlemen that were doing castrations in their oil shack that they had to do. Let's see here. You don't even have to leave the chat to support Crime Talk. Put up a super chat or super sticker. Just look at the down below in the chat box. Thank you. Some stuff I don't even know. Thank you all. And all right. So the other thing I want to talk about, obviously, is the cases. So if you have a question about, a case that we've been covering, feel free to put it in the comment section, and we will try to do that. And but the other thing I want to talk about is evidence, and I want to talk about hearsay, because I think that's one of the things that most people get confused about as to what's really admissible in court and why oftentimes it's so hard to bring a case against the defendant. You're just thinking, why are they not charging somebody? Well, the reason they have to do that is they actually have to bring in legal and competent evidence to do so. So I'd like to talk about that, but let's take a few more questions before we do that, all right? Let's see. What is the maximum penalty or length of time Lori and Chad are looking at if they're found guilty? I believe the maximum penalty is 5 years for each count of the obstruction, conspiracy to obstruct, one for Tylene, one for JJ. So it's 10 years total if those were maxed out and run consecutive. And then Lori Vallow has a couple of the other misdemeanor charges as well from the original case where they dismissed the more serious charges of abandonment, where Lori Vallow only has the basically attempting to lie to or getting Melanie Gibb to lie to the police. Shelley Jakes, good question. How do you choose the dumb criminal of the day? Well, in that, just like that famous opinion from the United States Supreme Court, I wish I could remember the name of it, but it was discussing pornography. And they're like, well, what is obscene? And the justices basically said, you know it when you see it. And that's how we select the dumb criminal of the day. You just know it when you see it. And you would be surprised how many people there are out there that could possibly qualify for the dumb criminal contestant of the day. Sometimes they don't qualify just to be a dumb criminal. Sometimes they actually get their whole story told and not as a dumb criminal. Now, obviously, the benefit of being a dumb criminal, right? What's the ultimate prize? That's right, a Crime Talk mug. We will send that to the winner. Every day, we select a Crime Talk dumb criminal contestant of the day, and at the end of the week, we summarize them, and you all have the opportunity over the weekend to vote. We tally the votes, and let's just say it's usually pretty overwhelming. I think only once or twice we've had to maybe have a recount because it was super close. But for the most part, it is pretty obvious. You got a real clear winner. Now, the lady today, I feel a little bad for her, Miss Jones, because she's been now a contestant twice. Today and roughly, maybe 2 months ago, I think. Clearly, she has some impulse control issues. Probably, I don't know. I mean, I really hope, and I don't mean to take light of the fact. I know some people don't like the dumb criminal contestant of the day. They think that we're being mean to people. No, we're not. And listen, I've said this before. When you deal with criminal cases that are, for lack of a better term, you get to see the worst side of humanity. You get to see the worst of the worst. You get to see people at their worst. You see the despair and trauma that is brought about on the victims of people's that are victims of the crime. And so every now and then you have to find something to laugh about it, okay? Because if you didn't and weren't able to laugh about it, you'd probably cry. And I've mentioned this before. There are a lot of criminal defense attorneys out there, and I would say just in the Denver area here, and is that we probably lose one defense attorney a year to suicide. And this job can be taxing on you. And if you sometimes can't joke about things, like I said, it'll absolutely just kill you. And I've seen it ruin lots of careers where people can't handle the stress. A lot of stress comes with it. You got to be able to handle that. You've got to be able to, joke about it. And sometimes if complete strangers were to walk into a law office or, the public defender's office, they would probably say, oh my gosh, that could be, some real dark humor. You are some sick people in there. Well, the reality is, like I said, if you can't joke about it, laugh about it, you'd probably cry, and you don't really know until you've been there, okay? Like I said, there are bad people in the world, and don't get me wrong. I am an optimist. I like to think that there are more good people in the world, and things usually work out the way they're supposed to. But there is true evil out there as well. And just giving everybody a big hug is not going to solve the world problems, okay? So sometimes, like I said, some people they'll send me an email or a message saying, Scott, why do you have to do dumb criminal contestant? It's just mean. These people have issues. I get it. And like I said, no one is more sympathetic to that. I mean, these are my clients. These could be my clients on any given day. I get that. But it doesn't mean that what happened is not hilarious in some particular way. And our dumb criminal contestant of the day, Miss Jones, it's her second time being a contestant. Her first time, she was exposing herself and pleasuring herself at a 7-Eleven in front of children. In that particular case, thank goodness a man was there to record it on his phone and show the police. My goodness. And then unfortunately today, Miss Jones was outside naked near a dumpster doing the exact same thing with the video camera is able to capture all of that as well. She lists as being homeless. So obviously there's some issues out there. Hopefully she can get the help that she needs. She hasn't been able to make the $150 bond. So needless to say, she is indigent as well. I've seen judges that work the dockets, and I'm sure I will offend someone by saying this, but they have the docket. It's usually the municipal court docket. It's usually the Saturday morning docket. All right, close your ears if you're going to be offended. All right, what does everybody refer to it as? They don't call it the Saturday morning docket. They refer to it as the municipal ordinance docket, aka nuts and sluts. It's cruel. That's not cruel. Maybe insensitive a little bit, but that's who appears that morning. People that got arrested for usually solicitation, or the John that got arrested for solicitation, and the female there for prostitution, and then it's usually the same suspects, the same people you see all the time. There's people there that are on a first name basis with the judge. They have grown old together, and the judge will say, you know what? Refers to him by his first name. Here's what I'm going to do. I'm going to put you in jail for 2 days. Hopefully give you time to get some food, get a clean shower, and, we'll send you back out there and hopefully won't see you for a couple more weeks. That's just the reality of it. Okay. And over the years, that's what they've referred to that particular docket as. I'm sure people will be offended to it, but I told you, I warned you, close your ears. If there's children in the room, turn the volume down. All right. Here we go. Question from Rita LaBoy. Scott, do you think murder charges will ever be filed against Chad and Lori? No, I really don't think they're going to do that. And I've mentioned this before numerous times when it comes to Lori Vallow and Chad Daybell. These charges that they have pending are the charges that relate basically for the death of JJ and Ty Lee. The prosecutor has to be able, they only get one bite at that apple. They don't get to say, oh man, we lost that trial, but now we come up with some new evidence. Now we're really going to charge him with some good stuff. You can't piecemeal it like that. All right? If they're going to bring the charges, they're going to bring the charges. You don't get to piecemeal the cases like that. So if the prosecutor is going to bring murder charges, they need to do it quickly. Now, I personally think that people related to this investigation, and this is my opinion, based upon what we've seen from the preliminary hearing, as well as the affidavit for the arrest warrants, and that is that Alex Cox had something to do with the death of both Ty Lee and JJ. And I don't see how or what evidence they're going to have to be able to bring charges against Lori Vallow or Chad Daybell. Being a horrible human being, right? Knowing that your children are missing doesn't make that a crime. There are lots of horrible human beings in the world, but it doesn't mean that they've committed a crime, let alone one that the government could actually prove. Now, one could certainly argue, Lori Vallow, why would she want to hang out and, go search for her children? She knows she's wasting her time. She's got more important things to do, right? She's going to go and head off to Hawaii and enjoy herself. It's kind of like that old story where, the attorney's in the courtroom and it's a murder case, and the attorney is going to try to raise reasonable doubt. And he says, now, ladies and gentlemen of the jury, in the next 30 seconds, the victim of the accused murder will walk through those doors. And everybody in the jury looks around, looks towards the door. The judge looks towards the door. Even the prosecutor turns around and looks towards the door to see if, the person that's the subject of the murder case, the victim, walks through those doors. And ultimately, they go off to closing arguments. They do what they need to do. Client gets convicted. And of course, the attorney is just shocked and appalled. Like, how could you have convicted my client? I had everybody looking at the door that the victim was going to walk through the door, and therefore that can't be murder. That's reasonable doubt. You all looked. You had doubts that the person was still alive. And the jury person said, yeah, everybody looked but your client. So, rule of thumb is, always tell your client what you're going to do if you're going to do something theatrical, right? But, one could argue, why was Lori Vallow not out there looking for her children, right? Think about it, ladies and gentlemen. If you have children and your child went missing, you would lift every stone, look under every nook and cranny for your child if you thought they were missing or something bad had happened to them. Who here, let's see a show of hands, would run off to Hawaii with your new boyfriend just 2 weeks after his wife had unexpectedly passed away? Which is a whole nother subject in and of itself, right? But think about it. Why would you go? You would go because you knew there's nothing to search for, right? But how do you make that stick to say that that is proof beyond a reasonable doubt? That in and of itself is not enough even to get probable cause to show that they were involved, that Lori Vallow was involved with the death of her children, Tylee and JJ. Simply is not enough. All right. So, so I don't think charges are ever going to be brought. I think based upon what we've seen from the affidavits, as it relates to the arrest warrants for both Chad and Lori Vallow, I think people in law enforcement believe that Alex Cox had something to do with the death of those two children, but they don't have enough to link it to Lori and Chad. And that's kind of where that stands. I just don't see it being charged unless Lori has confessed to Chad. And my thinking is that if he had something to roll on Lori Vallow, he probably would have done it by now and said, enough of this nonsense. Like, I would hope that he would say, this is not what I signed up for, right? Unless maybe they each have something on each other, the old mutual assured destruction, right? Remember that term back in the Cold War days where neither side would do anything. They wouldn't shoot their missiles at each other because it would be mutual assured destruction. Maybe Chad has something on Lori and maybe Lori has something on Chad. Who knows? And so maybe they'll just figure they'll go down together versus, rolling on one another because they know the others have something. I mean, that's a possibility. And I'm telling you right now, that is not a fact. I'm just telling you, based upon my experience as a criminal defense attorney, I have seen that where people will be like, I'm not talking unless you talk. And if you talk, guess what? I'm going to really let them know what I know. I've seen that happen before. All right, Rita, the other question is, don't let it go disappear. Hold on a second. My other question is why Chris Watts allows to have pictures of his victims in his cell. And so, Rita, that issue's gone on for quite a while right now. The normally, and I've never seen this, I had a homicide case where a client, he strangled his wife. Let's just put it that way. Strangled his wife. And had several of those, but this particular client wanted pictures of his wife. Like, ooh, creepy. Like, dude, you've been convicted of strangling your wife. Like, ooh. But he wanted those pictures, and they allowed him to have it. Now, I know in the Chris Watts case, he's probably allowed to have a certain number of family photos. I guess it's of his choice to do that. I think it's a little weird. If I was that warden there, I probably would not allow it. Because if someone's accused of crimes against children, you're going to let them have the pictures of their children? No, you're not. So I'm not sure why that still takes place. Apparently those are the rules, but hey, I'm not the warden. If that were the case, it'd be a lot different. Wayward, hello from Vietnam. Wow, we got a completely international people today. Thank you, Victoria. And thank you, Michelle. Wow, these super chats tonight. We don't always ask for those, but man, it makes sure a heck of a lot easier. Let's see. We have seen parents face more jail time for lying about school districts. There has to be some sort of, I didn't check on my kids for months and their bodies were found negligence charge. Yeah, you would think so, right? Marissa, you would think so. I mean, 5 years is what Lori and Chad face as it relates to each count. 5 years, so 10-year maximum. Couldn't be enough. Let's see here. Maybe, let's see here. They need to be put in the interrogation room. Michelle, thank you. $20 super chat, $19.99. Let's see here. Yeah, we're not going to talk about politics, and I could certainly talk about politics, but one thing I've learned in life, just like your mother always told you, you don't talk about sex, religion, or politics at the dinner table. Now, in the courtroom, you get to talk about, the elephant in the room, but we're not doing politics because basically you're going to piss off at least 50% of whomever is watching. So we don't want to go there. Let's talk true crime. All right, let's do that. Let's talk about some rules of evidence. Like I said, when we were talking about in the Lori Vallow case, Alex Cox, the now deceased brother of Lori Vallow. I think one could reasonably argue, based upon the affidavits, that the police believe that Alex Cox had something to do with the deaths of JJ and Ty Lee. The question is, how do they prove it? Just because it's on a piece of paper or just because it's on a report. For example, there's a lot of talk about text messages, phone dumps that took place. And they say, we got all these text messages here. Okay, think about it. You have a text message and you are texting another person. And it may say your name. And on the other side, you see the little things of the person coming through. Say it's your spouse, right? Some reason you have to go to court. Just because somebody says it took place, just because you have a text message about that, doesn't necessarily mean that the text message is going to come in. You have to be able to have somebody testify to what they said, all right? And that's why in court, it's so imperative that the prosecution have witnesses to come and testify. I mean, one of the important things about that is it's required under the Constitution, all right? There's a case called Crawford v. Washington. It's a United States Supreme Court case. It was written by Justice Scalia, and it was a case about basically a domestic violence case, if I remember the facts correctly. And the states, in that particular case, it was out of Washington state, they had to come up with these kind of relaxed rules about allowing in testimony of the victim of a domestic violence case who wasn't there. And, one of the things, we've talked about this, and for those who don't recall or haven't been around for those conversations, is the prosecution has to prove several things. They have to prove the elements of every charge, right? And one of the elements is that on or about the date and place charged, right? In the state and the county in which they're done on this particular date, that the defendant, not someone who looked like the defendant, not someone using the identity of the defendant, but it was actually the defendant, did certain things, touch somebody, grab them, cause them bodily pain. The elements, say, for a third-degree assault. But you need somebody. Think about it. Most domestic violence cases happen, in the back bedroom, in the kitchen. Maybe nobody else is there. So you need somebody to come in and identify the defendant. That's the bad man over there that did this to me, right? You have to be able to identify them in court. So the rules got relaxed in a lot of ways, saying, well, if the victim made a statement to the police officer and it was made kind of in the heat of the moment, it's probably reliable. And then somebody said, well, she was upset and now she's changed her story. Well, but if she's had time to reflect upon it, then it's probably reliable too. So they fashioned all these reliability tests to come up with. And in Crawford v. Washington, the United States Supreme Court said, oh, no, you don't. You got to have the victim. It's the Confrontation Clause of the United States says you have a right to confront and cross-examine all witnesses called to testify against you. And to allow in hearsay, okay? Let me give you the easiest explanation of hearsay. What isn't hearsay is if somebody comes into court and puts their hand up and swears the oath, you swear and affirm under the pains and penalty of perjury, tell the truth, the whole truth, and nothing but the truth, okay? And they say, yes, I do. And they sit down in that witness chair. What they say that they saw what they say that they said to somebody is not hearsay, as long as you, the person testifying, said it. If the witness on the witness stand wants to testify to what somebody else said, what somebody else wrote, that is hearsay, ladies and gentlemen. As a general rule, it is inadmissible. And the court shouldn't allow it. But like everything in the law, and the first thing they teach you in law school is there's always an exception to the rule. Now, one of the wonderful subscribers, viewers here, Teresa, said, well, excited utterance, ? What about excited utterance? I'll talk to that in a quick second. Okay. But so Crawford v. Washington said, you got to bring in the witness. You got to do that. You have to have them testify to what they said. Now, let's say the victim of our hypothetical DV case, on the night in question says, yeah, my boyfriend is the bad man. He did terrible things to me. He hit me. He threatened me, scared me. And then, of course, she, realizes, hey, wow, he's maybe not that bad of a guy, and I really don't have any money, have nowhere to live. So I guess I need to be nice to him so it doesn't happen again. So I want to recant my story. So the witness, not wanting to face a contempt charge, goes to court, testifies and said, yeah, I called the police. Yeah, I said he did those things to me. Yeah, he's sitting there in the courtroom, right? And the defense attorney gets up and said, you made all that up. You exaggerated everything. That really didn't happen. At most, you exchanged a few bad words. Isn't that true? And she says, yes, that's true. Right? No hearsay. She's testifying as to what she said. But guess what? The police officer that she made that statement to can then come in and impeach her. And statements to impeach the witness are non-hearsay. So the prosecutor then brings in the police officer, says, sir, did you respond to this location on this date and time? Yes, I did. And what did you do there? I responded to a domestic violence case. And the prosecutor then asks, and with whom did you speak? Well, I spoke with the victim in this particular case. Okay. Now, did you ask her any questions as to who did this? Yes, I did. Who did she say? The defendant, the bad man over there. Officer is then asked, did you ask her specifically whether she was upset or angry or this actually happened? Oh, I asked her if this actually happened, and she said it did. Right? The officer's testifying to what somebody else said at a different time and location. Hearsay. But to impeach a witness on their statement is not hearsay. Okay? Additionally, anything the defendant says can and will be used a defendant in a case all the time. That's what happens. That's why you always tell your clients, shut your mouth. Don't say a thing. Anything you say can and will be used against you. It'll be misconstrued, taken out of context, misinterpreted in any way possible to make you look bad. And it's better to look guilty than to be found guilty, so shut your mouth. So, if the defendant says something to his neighbor, wow, like Lori Vallow, yeah, I'd really like to really harm that person. Yeah, that can come in. May not be enough, but maybe it's enough pieces in the puzzle that the prosecution has to put together. Okay. But the reality of it is anything that the defendant says. Now, let's say the defendant gives a statement that is what they refer to as self-serving. Like, oh, yeah, I was there on the date of this scene, but I didn't do anything. In fact, I was the victim of her. She attacked me. Let's say use our DV example. She attacked me. I was defending myself. So, yeah, that's it. Well, the prosecutor can choose to put that statement in as evidence, or they don't have to. Now, wouldn't that be nice for the defense to say, hey, he gave a statement. It was all self-defense. Yeah, the defense can't submit their own witnesses' statements into court. They have to testify. Now, if the prosecution introduces that statement and they say, well, there's a 5-minute interview and there's only 30 seconds that the government wants to play, then the defense can certainly bring it in under a rule of completeness. But the reality of it is The defense cannot bring in self-serving hearsay. The defense can't bring in, man, my statement to the cops was the truth. It was the truth back then. It's the truth now. I don't want him to be subject to cross-examination because people get nervous and say things. So I'm just going to submit his statement to the cops. Doesn't work that way. Doesn't come in. All right. So hopefully that explains the rules of evidence as it relates to hearsay. All right. Now there's a bunch of other exceptions that come in. Excited utterance, not so much. The United States Supreme Court put a kibosh to the excited utterance rule, particularly in DV cases. It's still an excited utterance, but it's something that's made in the heat of the moment. Like somebody's looking out the window and they say, "Oh my gosh, the car's going to run the red light." Okay, that can come in because everybody suddenly turned their heads towards them. All right. There's not any time to sit, pause, think, reflect. It just kind of happens spontaneously. Excited utterance. Then you have dying declarations where somebody could testify as to what they said. We've talked about this in the past where I had a case where my client maybe pinned his wife between a car and a house and she lost her leg. And by the time the paramedics showed up and she's laying there and said, "My husband did it. My husband did it. I'm dying." Right? Dying declaration. You have to actually believe that you're dying. You can't I scraped my finger and I think I'm dying. And, it's a hearsay statement. It doesn't come in. Dying declaration. I'm dying. I'm dying. Tell my mama I loved her. And, oh, by the way, my husband is the one that did this to me. That would be admissible if the person passed away. The paramedic people could come in and testify to that because that is the classic case of a dying declaration. All right. So like I said, there's always rules in the law and there's always exceptions to that. So hopefully that helps explain that somewhat. All right. We are just about at our hour mark here as it relates to this, but we will be going to our Patreon live here shortly. So if you haven't done your Patreon membership, now would be a good time to do it. Continue the conversation. I'll answer any questions you have, and we'll give you the super secret number to call in where we can have an actual conversation and not just deal with text messages back and forth. So I want to thank everybody for tuning in. But before we go to CrimeTalkSearch.com, sign up for that background subscription service. It's a valuable tool. We use it here every day, and you can get a background subscription search done literally while you wait. Depending on the package you get, you can get as many as you want, and you're going to get all that information about people's marital records, property records, business relating to business entities they own, bankruptcies, judgments, criminal history, social media, so important these days. What is really going on out there? And then obviously emails and phone numbers as well. So go to CrimeTalkSearch.com. You'll be happy you did. We'll be signing off, and we will see you at the Patreon live here in probably less than 10 minutes or so. So have a wonderful, wonderful evening. Thanks for watching Crime Talk.